Appeal parted in the matter of McGaughey and another Universities Superannuation Scheme Limited and others.
Yes.
My Lord, good morning. I've got to ground C, which concerns, as it were, the view taken of the merits of the underlying claims by Mr. Justice Leech. And the specific ground of appeal is whether he erred in holding there was only a prima facie case where there were issues of fact on which it would be wrong to accept the claimant's evidence without cross-examination. And I certainly don't suggest that that is a universal test to be applied in every case. Now, there must be some consideration of the merits in deciding whether to give permission. And the common law derivative or company derivative claim cases do all use the phrase, or many of them use the phrase, prima facie test. But in my submission, what is required is for the case to be good enough in all of the circumstances for it to warrant further proceedings. And that's not easily dealt with by a one-size-fits-all form of words. And the approach that was taken here was appropriate to the nature of the claim in this case. Because this wasn't a case where the claimants or one of their witnesses said, we saw the directors putting the goods in the boot of their car, and there was another director said, no, that was my swimming kit. And so there wasn't a question of fact of that nature that needed to be determined at trial. Instead, the essence of the case was that the things that were done, and there was no dispute as to the primary facts. The AVR had an as-at date of March 2020. The blended single discount rate was CPI plus 0.29. But the issue was, why were those things done? Was there a good reason for it? The first of the issues. Then, what are the consequences of the answer to that question? So it was inevitable that the explanations put forward by the company would be scrutinised. And that's what Mr. Justice Leech did. He did not simply assume that anything said on behalf of the company would be accepted, and nor did he assume that anything said by the company in the contemporaneous documents, because the case was based entirely on contemporaneous documents that were before the court. He didn't simply assume that anything in a contemporaneous document would necessarily be accepted. He examined the documents in some detail and said, well, is there any reason why they might not be accepted? And there was no such reason. That was...
Well, we asked Mr. Grant yesterday in the context of one of the documents whether it was being said that what was said on behalf of the company was untrue or somehow misleading or a lie. And there is no case, as I understand it, no case put forward by these applicants that when your clients, or the directors of your clients set out what they set out in the publicly available documents, they were somehow misleading people.
Yes.
The real issue was whether the explanation that they provided was one which supported your case or their case.
Yes, my lord. Although Mr. Justice Leech does make a finding that they had no realistic prospect of going behind the documents in the sense of showing that the document set out a false paper trail or didn't set out what happened. The highest it could be put is that the claimants disagreed with the conclusions reached. But there's
The pleading case, at least, was that the only rational explanation for what had been done was that there was an ulterior purpose.
My lord, yes, although I understood the claimants to have retreated slightly from that position yesterday, in that they no longer maintain.
Had they retreated? I mean, what was the position in front of the judge on that? I mean, he looked at the pleadings, I assume, like everybody else.
Yes. I don't think it was as clear as it was yesterday that there was no allegation of bad faith, but that case was, as it were, rejected when the judge found that the documents didn't, or there was no prospect of showing the documents set out a false paper trail. The other point made yesterday is that it's not suggested that no reasonable body of directors, presumably no reasonable trustee, would have been unable to reach the decision that the discount rate should be CPI plus, blended discount rate should be CPI plus 0.29, or that March 2020 was an appropriate date for an APR. So now, as the case is, it is, in my submission, it's reduced to being a suggestion that a different view could have been taken, which doesn't begin to satisfy the requirements for any breach of director's duty. But in any event, Mr. Justice Leech, in my submission, was quite entitled to say, on the evidence, there's nothing that needs to be considered further. Now, there is, in my submission, there's no hard-edged issue of law here anymore. I think at one point, certainly, the claimant's position was that the court should not look at any of the evidence adduced by the defendant in response, but that's not maintained. That was always an unarguable position.
So you're saying, Mr. Short, a judge in this circumstance, at the second stage at least, should look at everything, that's the totality of everything that's before him. It depends on the issues, it depends on the kind of evidence, the circumstances which he finds himself in. But in these circumstances where you've got documents and there's nothing to suggest that you can go behind those documents, then he was perfectly entitled to accept the documents, and that is in effect what he's saying when he says, I think it's at 43, about accepting them, unless he could see that they ought to be tested by cross-examination.
Yes, my lady, that's not an unusual position. I mean, I think somewhere it suggested that on a summary judgment application, the court will accept the claimant or the defendant's allegations of fact. And of course, ordinarily that's true. The court will be very well aware of the Easy Air decision. It's not always true if it's obvious from contemporaneous documents.
Well, maybe the documents, that there is a sufficiently arguable case that the documents don't tell the truth or seek to, as you put it, set out a false paper trail. But that's not this case, and that was never suggested.
My lord, that's right. Or it may be suggested that because of some of the evidence, there's likely to be further documentation that will cast things in a different light. But there must be a proper basis for that suggestion. One can't simply hope that something turns up or hope that when they're being cross-examined, a witness blurts something out.
That's McGaughey, isn't it? Which is never.
There has to be a proper basis for saying something should go. Something should be examined in more detail. Now, I accept that in many cases it will be more complex than just, is there a prima facie case? Because it may be that there might be an arguable case, but it is very, very close to the line. It won't produce much money. It will cost a fortune. So it wouldn't be appropriate for the matter to go forward. But if you don't get over that initial test, then it is not appropriate for it to go forward. Very, very difficult to think of circumstances in which it would be. In my submission, it really doesn't any consideration of whether the test here is, well, are the claims better than frivolous or not, isn't really in point. Firstly, I'd submit the claims aren't frivolous. But even beyond that, on the facts of this case, the judge was entitled to say there's nothing here, nothing that needs to be explained further, given the allegations and the evidence that was available. I'm not proposing to go to any of the authorities, Prudential, Waddington, Averroes, Buller, because the court's seen them already. The only additional authorities, there are some US and Canadian cases in my learning friend Skeleton. We've responded to these at paragraphs 73 and 74 of our Skeleton, but I don't think they take matters any further.
Are you going, speaking for myself, I'd be interested to understand what you say the correct approach is in trying to reconcile the corporate law duties under section 171 and 172 of the Companies Act, which directors of this corporate trustee are said to owe
Yes.
to their company, what they do owe to their company, and the duties in the context of a corporate trustee of a pension fund. Because I had quite a few exchanges with Mr. Grant trying to drill down to how you bridge that
Yes.
gap. So that, for example, if you have the director of a company must only exercise powers for the purposes for which they are conferred, and Mr. Grant says, well, the purposes of this company are not just, as it were, to be the trustee of a pension fund, but he draws, I think, a more direct line to advancing the interests of the members of the scheme. And in the same way, he says that section 172, the director must act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole, must be read subject to section 172 too, because he says, no, the purposes are not to confer benefits on the members of this company, because they're members of the directors.
Yeah.
So the purposes are, as it were, either being a corporate trustee, or more specifically, I think he says, being a trustee of this scheme.
Yes.
So what I'm interested in hearing is your position on how to read the director's duties, which are at the core of the claim which Mr. Grant wants to make, in the context of a pension scheme, because it's a question that has provoked quite a bit of interest in the authorities, not least Mr. Justice Miles, as he now is, decision, I think, in Gregson.
Yeah.
And in a sense, it's all very well saying, well, is the test a prima facie case, or is it something higher or lower, or look at the evidence or whatever? But actually what I'm trying to understand is, how do you formulate directors' duties in this particular context? Which is, I suspect, in the pensions industry quite common.
Yes. Well, my lord, if I literally have 4 short sentences before my heading is fiduciary duties.
Okay,
So
that's fine, you are going there.
I'll deal with the more general points first. This is an exceptional remedy, particularly if combined with a prospective cost order. But even if it isn't combined, it is a hugely disruptive and expensive process. So the test, merits test, however it's raised, has to be more than this might work. If it's for the benefit, if a claim is to be brought for the benefit of the company, other than in very exceptional cases, well, in my submission, it would need to be, the merits would need to be more than just not frivolous, because a reasonable board of decision makers would not launch expensive proceedings just because they weren't obviously hopeless.
You know, this is now in a sense moving to what would in the corporate context be the second stage.
Yes.
It would be going beyond the prima facie filter, if I can call it that, and moving to the second inter partes question, which is, whatever the merits are, is it something which an independent board of directors acting in accordance with their duties would consider to be in the interest of the company, having regard to the interests of their members?
My lord, yes, and when making that decision, the fact that the claim has prima facie merits, or to use a different expression, is not barking mad, is the one thing that the directors have to put a lot of weight on. It may not be the only thing they consider, because, as I've said, it may get over that test, but still be expensive and risky. And
But as I understand it, because this is not actually proceeding, but because the stage which we have now reached was an inter partes stage.
Yes.
Indeed, whether you go direct to an inter partes stage, in a sense, the question of whether there is, quotes, a prima facie case becomes somewhat of a sideshow.
Well,
I mean, because unless the company, when it comes back into parties, can say, actually, the provisional view that the judge formed that there was a prima facie case, whatever that means, was wrong, then you're always going to have this balance of how good is it as opposed to what's the economic cost-benefit analysis, if you will, for pursuing it. So it's always going to be a more nuanced exercise.
my lord, yes, it may be that one's still looking at whether there's a prima facie case, bearing in mind the explanations. We think this would actually be a good example of that. But it doesn't, I agree, it certainly doesn't matter what the test, what expression is used to try and condense.
Well, I mean, one consideration for the directors would be if they're advised that the case would be capable of being struck out under the strikeout test, then by definition there's no sensible basis in carrying on with it, because all you're doing is going to be struck out with costs. So, you know, in other words, at that stage, you know, you can ask, in a sense, the court will ask itself that question rather than the prima facie test, I suspect.
So certainly, my lord, I don't suggest the words prima facie test are essential. They've been used in the past repeatedly, but it may be that we're past their utility when one comes to an inter partes hearing. And for example, in Avaraya, prima facie test was said to require more than at least more than just seriously arguable. So it's quite a strong prima facie test, but that is because it is intended to encapsulate the entire decision-making process in the submission. Now, moving on to fiduciary duties, but before turning to the claims themselves, it is worth noting what the claimants were seeking to prove, which isn't just that it was wrong to hold an AVR with an ASAP date of March 2020, or the discount rate was too pessimistic, but that the directors were in breach of their fiduciary duties in doing so. And the application that was made, and the appellant's case, seems to move, in my submission, seamlessly from the suggestion that those decisions were wrong to a suggestion that there was therefore a breach of fiduciary duty, a breach of the statutory duties on section 171, section 172. And that is, in my submission, quite wrong. The basis, factual basis of the allegation seems to have been reduced to the suggestion that the directors had misunderstood the obligation that lay on the trustee to ensure that accrued benefits could be paid. Now, I don't accept the premise. I don't accept that the directors had misunderstood the law. And the primary role, primary duty of a trustee is to ensure that the benefits due under a scheme can be paid. But even if the directors had misunderstood that duty, despite the advice, misunderstood the trustee's duty, despite the advice that they had, it does not mean that there was a breach of section 171, 172. Because there has to be something more than making a mistake. We've dealt with the, as it were, the company law issues in our skeleton argument, which is in the core bundle at tab 8, at paragraph 93 onwards. And
I mean, just as a matter of detail, perhaps, but I don't think the 171 duty to exercise powers for proper purposes is necessarily regarded as fiduciary. I think it's I mean, the duties are what the duties are said to be. I mean, there's perhaps a nice academic debate about that, but I don't think anything turns on whether they are regarded as fiduciary or not in this context, does it?
my lord, yes, I accept that, but section 171, the application of section 171 does involve giving credit to the bona fides, the bona fide views of the directors. And it is not enough to say the director was wrong as to whether a particular step was in the best interest.
Well, I mean, the powers have to be exercised for proper purposes. I mean, the court has to reach a view as to what those purposes are.
Yes.
I mean, a director could honestly believe that the purpose for which he's exercising it is the correct purpose, but if as a matter of law it isn't, then why isn't it enough that he's wrong? I mean, I mean, I think what in Howard Smith and Ampol, Lord Wilberforce, for example, does say you might give some weight to the director's beliefs as that was an issue of shares to frustrate or to keep a majority in power, I think. You've got to give some weight to what the directors honestly believe the purposes are, but ultimately isn't it an objective test?
Yes, my lord, yes.
Well, I'll come back to me on it. I mean, but I mean, yeah, I mean, it's. I mean, there's quite a lot of that in Claire's, isn't? I mean, Claire's is the leading authority now on purpose, isn't it? But I mean, I think the way it's put is if the directors got the purpose wrong, notwithstanding the advice they'd received, the purpose is wrong. And that's just a straightforward question: is are they acting for proper purposes? I mean, I'm just wondering.
Yes.
Do you have to overlay anything onto that?
Well,
in terms of purpose.
in order to decide whether the purpose was proper, at that stage you do give some credit to the directors, the bona fide views of the directors.
Does proper in that sense mean anything other than correct?
No, but the directors are entitled to take a view, and that must be given some weight because it's the directors who are there to administer the company and direct the company, and they get to have some say. The court won't step into their shoes and make the decisions for them. It will have to give some respect, some deference towards the...
That's normally said in the context of normal companies, because normal companies are commercial entities, and in a sense how a board of directors goes about conducting the business of a commercial company with a view to profit does involve judgments about what to do, what area of business to go into and the like. But there are certain things you can't use powers for as a matter of law. So, for example, you can't use the power to issue shares for the purpose of perpetuating control by the majority. It's just not what the power to issue shares is there for, as a matter of law, says the House of Lords. And it's in the particular context of a pension fund, which is where I struggle, because I don't probably fully, I'm not fully able to join the dots. The way it's put is that a pension trustee, there are two ways it could be put, I think. One is that the company directors must ensure that the company of which they are directors does not act in breach of the trust which is imposed on it under the pension scheme. So the focus is then on how does a pension trustee, what are the duties of the pension trustee in relation to the administration of the scheme?
Well,
the other way of looking at it is to try and sort of smooth that over and cut the corner, or whatever you want to call it, and go directly from the directors through to the administration of the pension scheme.
Well, my lord, I don't suggest that's the approach, although it may not be very different in practice. I say the test to be applied is the same in a company limited by shares and companies limited by guarantee. What might be different is what the purpose of the company is, because the purpose of the company isn't to make a profit. So that much we know. So the purpose of the company, I accept, is to act as trustee. The duties on the individual directors are no more onerous because they are the directors of a trustee company than they would be if they were individual trustees. So they have to act for the purposes of the trust of the scheme. But they are entitled, in doing that, to take a view as to what is in the interests of the
sorry, Mr. Short, I'm just wondering whether you're mixing up two things there. Yes, I can quite see, and that's the last part of what you're saying, that what is a proper step in relation to the administration of the trust may be a matter of judgment, and you're looking particularly at what to do when you've got all these assets and all of these liabilities and all this actuarial advice. What do you do about it? And you would say, to some extent, that's a matter of judgment. And I think that's what you're getting at the tail end of what you just said. But before we get to that, I just want to be sure about the front end, which is, I'm not sure whether, and I just need to be sure, about whether you're saying the duties of a director of a trust company, of a single pension trust, is to make sure that the trustee, of which it is a director, does not act in breach of trust, which is a basket of everything that the trustee must do in relation to the scheme, or whether you're saying, which I think you did say also, that in fact, in practice, it makes no difference, and therefore those individual directors have to, their duties are to make sure that all the administration and all the decisions in relation to the scheme are within the proper use of those powers. And I do see that there's a difference between that, because then you're actually running those directors through into the scheme, rather than saying what they've got to do is leaving the trust company as an entity in this structure, and that they are having to make sure that that entity doesn't act in breach of trust.
Yes.
There may be no difference either, but I just...
No, I think my submission is the first of those alternatives.
So they need to make sure that their trust company acts properly as a trustee of the scheme.
Yes, and those duties are owed to the trust company. And in that's why I say it's no different in principle from any other company director. It is simply that the purpose isn't to make a profit. It is in a trust company where it's a pension trustee. The purpose of the company is to administer the scheme properly and to cohere and to comply with its duties as trustee, and the directors are to ensure it does that. If it was a company limited by guarantee in the housing arena, it would have different obligations, but the company would have different obligations, still not to make a profit, but properly to administer an estate or a block of flats. The directors would owe duties to the company to ensure that it did that properly, but the duties are owed to the company, and the company has to act in a particular way. And the director's purpose of the company, which are to be furthered, powers to be exercised by the directors in furthering that purpose, are then identified by reference to that purpose. But it will always be fact specific as to what the exact duties are. But they are shaped by the duties of the trustee as a trustee.
And then you say that, as I think Mr. Grant accepted yesterday, that then the duties of those directors under 171 and 172 are owed to the company, the trustee company.
Yes, the duties are owed to the trustee.
Inevitably.
Yes. And here, it's not, in my submission, clear why those duties were, or the duty to act for proper purposes can be said to have been broken or exercised for an improper purpose, because they were certainly exercised with a view to ensuring that the trust scheme could pay benefits due under it. And that is the single most important duty of the trustee company. And so the gap in the appellant's case, it's always been there, is that it hasn't explained why there was a failure, or why the powers were exercised contrary outside of their scope when on any basis they were exercised in order to ensure that the scheme could pay benefits that had accrued.
So you say also the analysis is 171 and 172, directors owe duty to trustee company to make sure that trustee company acts in a proper way in its capacity as trustee.
Yeah.
And here you say there's no breach of trust by the company, so there can't be any breach of directors' duties.
Yes, the directors in my submission cannot be held to be in breach of duty under 171 or 172 for doing something that would not have been a breach of duty had they been individual trustees. Yeah. That may only be a practical test rather than a strict rule of law, but that's the position. Yeah. Now, I'm not sure that answers my lord, my lady's questions, but that's as far as I think I can helpfully go on this. And unless I'm asked another question, I'm going to move on to the claims themselves and just deal with the merits of those claims. Two main complaints: use of March 2020 and the use of assumptions that were said to be too pessimistic. The evidence is dealt with from paragraph 80 onwards. For the court's note, that's tab 16, page 202. Mr. Justice Leech returns to some of the key passages in relation to the AVR, certainly at paragraph 147. The company has repeatedly explained why it chose to proceed with March 2020. Not simply in response to this claim, but transparently and repeatedly in the year leading up, the year and a half leading up to the issue of the claim. An AVR was preferable to a report because it provided for much more flexibility. If an actuarial evaluation hadn't been carried out, contributions were going to increase in any event as a result of the 2018 valuation. They were due to go up to 34.7%.
Are you going to take us to a document which encapsulates all this?
Yeah.
Because
Yes.
if you are, then I won't bother to write it all down.
Yeah.
But if you
Well, I think it's the easiest place to find that is in the core bundle, page 315.
Core bundle.
The core bundle. There's not much in the, and this is in the tab 20, the amended particulars of claim. There's not much in it I agree with, but I do agree with this bit, so
Right.
I'll use it. But paragraph 49, further contributions were due to, or contribution increases were due from October 2021 up to a total of 34.7%. And that was unaffordable. That was going to be unaffordable. It was particularly going to be unaffordable to the employers who had made clear that they didn't have any money because COVID meant they had no overseas students. And a main source of cash income was being denied to them. and that's referred to in the evidence. So it wasn't a sensible option simply to say, well, we'll do an annual report, we'll keep going for another year, because that would have involved increases to contributions being imposed. But what's more, they said we can always, they said repeatedly, it's dealt with in the judgment, I'm not going to go to all of the documents, but we can keep things under review in order to see whether we should in fact proceed with the 2020 valuation. And there are two documents I will ask the court to go to. The first is in the supplementary bundle number 2, in part B of that bundle, the second bundle, tab 43, at page 457.
And this is the explanation.
This is the explanation, and I dealt with in the judgment, but it encapsulates the position at that time. This is in March 21, and on the final page, page 459, it is worth submission noting, under considering our duties, it says we have specific duties under common law, statute and the regulatory regime, including ensuring that the scheme has enough assets to cover its liabilities as required under the statutory funding regime. So members' benefits can be paid when they fall due. That is an accurate statement of the law. But on top of that, one of the things that's constantly done is in reviewing the up-to-date position. We see that being taken into account in the actuarial valuation report itself, which is in the same bundle, in tab 56 at page, so tab 56 is the valuation report. This is from the schemes actually, statutory appointment, statutory role rather, is appointed by the trustee.
Sorry, tab 46 did you say? Sorry, did I get that wrong?
Tab 56.
56, sorry.
And this single fact in itself shows why the claimant's complaint is
So where is it?
misconceived.
In this document?
Page 604, my lord. And this is experience since the valuation date. And in essence, the actuary explains that although the assets had bounced back, one of the difficulties with that is that future returns were also expected to be lower. As it happens, inflation, CPI, was expected to be rather higher, so that if a valuation had been carried out in March of 2021, or with an effective date of March 2021, the overall contribution rates were going to be slightly higher. So the difficulty with the appellant's case is that they've only address a single feature, asset value, and ignore everything else. But the company directors had been monitoring this position all the way through. There's another document dealing with an earlier comparison in the Rule 76.1 report itself, which is at tab 40, pages 382 and 389, that reaches more or less the same conclusion at an earlier date. But this is the point. If it had been done 2021, it would have been no better, very marginally worse.
And at the bottom of that table on page 604, it says future service rate, but then revised benefits in line with JNC recommendations. So
Yes.
that's on the basis of the scale back.
Yes, that's right. So, I mean, if the benefits hadn't been scaled back, there's no reason to think that the underlying results would have been any different. In fact, it probably would have been worse because there would have been more going forward and it's future service contributions that have risen. So the claim is essentially flawed. It's based entirely on a standard form note in the schedule of contributions, which is at tab 59, page 638. And this is where the actuary certifies, because the process is quite heavily controlled now by statute. And the actuary has to certify the schedule of contributions. And he does that. And on the second page, you'll see there are notes. Don't form part of the certification, but in the second paragraph, the actuary says, furthermore, in providing this certificate, I've taken no account of either adverse or beneficial outcomes that have become known to me since the effective date of the valuation. Pausing there, that's entirely unexceptional as a statement. The certificate is signed 18 months after the effective date. If there have been no changes to anything, then it doesn't matter. If there have been changes in the financial circumstances, then you would never be able to certify a schedule of contributions because things would move on a daily basis.
Target all the time.
So this is, I say, unexceptional. Nothing can be. That's not a suggestion that in the process as a whole, the improved asset values had been ignored. It is that the schedule of contributions was based on the as-at date.
Can I step back a second? As I have understood the process, the process is that is this right? The setting of contribution levels consequent upon a valuation is in fact a decision for, well, technically it's a decision for the directors under the scheme rules, but they have to implement what the JNC says unless they've got certain set out specific reasons not to.
That's in terms of benefit design. But for the statutory duty, I think, to ensure proper funding is on the trustees.
Right.
The trustee. So the directors have to achieve that.
I'm just going back to the sort of proper purposes argument. I had understood that the case that was being advanced by the claimants was that the directors chose to do a valuation by reference to the 31st of March 2020 to pressurise the JNC in a certain way, and that was said to be an improper use of their power. I mean, the point was made that they weren't obliged to do it, but I don't think that gets anybody anywhere. The question is, what was the purpose of the directors, as I understand the case, it's being put on proper purpose. What was the purpose of the directors in choosing this valuation date? And it said it was done for a purpose other than that for which it was conferred, namely to pressurise the JNC. And I'm just trying to make the link in my own mind between the JNC's role and the role of directors in the process we're now looking at.
But what happened here is the funding obligations are on the trustee, statutory obligations are on the trustee. the trustee says, effectively, well, the actuary produces the section, the Rule 76 report, which says various things. If you continue benefits on this structure, these will be the contribution rates that will need to be paid. The JNC then has a choice between agreeing to those contribution rates or changing benefits, because they are the only two things that can be done to balance the book. If it decides to change the benefit structure, then the trustee, under the rules, has to agree to that, save in very limited circumstances. So that's how it works. If the trustee had been made by the directors to produce, to force benefits down, not for the purpose of ensuring the scheme could pay for benefits, but if it was being done because employers didn't want to pay pensions, for example, that would be stepping away from the purposes for which the power was given.
What I'm not quite clear about is you're showing us this document, I think, to try and suggest, well, that the claimants would have been worse off had it. Well, I'm not. You're
Yeah.
Showing us, as it were, focusing on the result to the claimant if things had been different. But I thought the focus of this whole exercise was on the purpose for which the directors were doing it.
That's
I mean, to say the claimants wouldn't have been any worse off, just it's going right to the end, to an end game, rather than attacking the case.
It deals with both of those things, my lord. The appellants say there was no good reason for sticking with 2020, and it was only chosen to force benefits down. And I'm showing the court this document, or these suite of documents, to say there was a good reason for 2020, and part of the decision-making process was that the position was not going to be any better for the scheme in 2021, and so it would have been no better for the members in 2021. The decision to have a 2020 as at date wasn't only rational, it was far and away the most sensible thing to do. I don't need to show it was far and away the most sensible thing to do. I only need to show it was within the range of possible decisions, and I don't think it's said to have been a perverse decision, but this was a good decision.
And even once they had, let's put it colloquially, once they kicked off the process for ASAP 2020, they still could have decided, whilst the figures were being amassed by the actuary, that actually they wanted it to be ASAP 21.
Yes, if there had been...
It's not as if you jumped off the cliff.
No. If during 2020 there had been a very substantial increase in gilt rates, which I'm going to talk about in a moment, so that the entire basis had changed, so that you could continue to pay the old, continue to provide for the old package of benefits with much lower contributions, then the trustee would have responded to that. But the position wasn't that. By monitoring the economic position, they were advised it will not be better if we move the as-at date back. The essence of the complaint, I think, as it was put yesterday, is the suggestion that the discount rate was too conservative, too prudent. And the appellant complains about the rate being 2.9% above CPI. Now, CPI was assumed to be 2.1%. I'll come to the figures in due course. So overall, this was assuming a rate of return of about 2.4%. That's a blended rate for all investments. It makes it slightly difficult to compare it to the AVR itself because the scheme tended to express discount rates in relation to gilts. So it says gilt plus 2.5 rather than CPI. And secondly, following the Joint Expert Panel recommendation, it separates the discount rate into a pre and post-retirement rate. And if I'll explain why in a moment, but that we can see that at tab 56. This is the AVR at page 597.
Do we need all this detail?
Well, I don't know. I think so, possibly, but I just want to explain. If I'll use 5 minutes just to explain what's happening here. There are
Sorry, page number?
Page number 597. And you'll see the return from gilts is thought to be 0.7. This was a historically low gilt market. The pre-retirement portfolio, that's people who haven't retired yet, is either 2.75 or 2 above gilts, depending on whether the changes were going to be made. And the post-retirement portfolio is 1% above gilts. The reason you have a different rate pre and post-retirement is that you can take more risk with people who haven't retired yet because you've got longer to make the money back.
Yeah.
For people who've retired, you need the money now. And the blended rate takes all of these things in together. But it's not entirely clear what's said to have gone wrong, which bit of the calculation the appellants don't like. The Aon report you saw yesterday didn't have any complaint about the post-retirement portfolio of 1% above gilts. So the whole of the appellant's complaint is focused on the pre-retirement portfolio. But all of it deals with the rate of return on every asset within the scheme. Some of them, or quite a lot of them, are gilts, which we know are expected to return less than CPI. So they're effectively, they're not growth assets. In fact, they're going to be loss assets. They're very safe, but there's going to be a funding shortfall that needs to be made up on the other types of asset. And again, it's not entirely clear where they say this is the types of assets, where they say this is wrong. The consultation document, and I've nearly finished this part, which is at tab 33. This is in Supplementary Bundle 2, Part A. Now, hopefully this included the expected returns on various asset classes relevant to CPI.
Sorry, page?
222.
Two through two.
222.
222.
You'll see there's a table there, table 8.1, that says equities on this model were expected to return 4% and a bit above CPI. Property just 1.8%, gilts below CPI. And we don't know which of these is said to have been wrong. The appellants simply don't like the outcome. The final thing I'll mention is that they've completely ignored the reliance upon or the allowance for overperformance. So because assets have bounced back, the scheme had made an allowance of 0.5% for overperformance. And I'll just show the court that document, which is, I'm sorry, to jump back into bundle B, tab 57. And because of the market conditions, this is the recovery, the statement of funding principles that was produced as part of the whole exercise. But at 626, to paraphrase, under investment return on existing assets, future deficit recovery contributions, the funding arrangements had made an allowance of additional investment returns of another 0.5%. So that's not included in the CPI plus 0.29, and they make that allowance because of the unusual market conditions in March 2020. Effectively, it says we're going to assume CPI plus 2.9%, but we know we're going to do better than that because of what's happened in the 12 months since 2020. So we're going to make an allowance of an extra 0.5 over the next 18 years, 0.5% a year. So the figures are better than the figures that the appellants complain about.
And so might that be a complaint that it's going to be better and you've acknowledged it's going to be better, so why did you cut benefits in the way you did?
Because this acknowledgement that it's going to be better is allowed for in all the figures. So
that's already gone into where one ends up.
Yes. So it's already gone in, it's been taken into account, and we see that, I mean, that 626 is about the deficit repair contributions, and then 627, the future service contribution rate also makes allowance at 0.5%. But we simply don't know why the appellants say the trustees couldn't or shouldn't have chosen these figures, other than the fact we know they don't like the outcome. And if one puts aside any suggestion of bad faith and puts aside any suggestion that no reasonable body of trustees or directors could have reached these decisions, all they have is to say, well, this was wrong, and that's not enough. Claim, I'm going to move on to claim 2 now. It may be that I don't need to do...
What's striking about this is this statement of funding principles actually says at the outset that it's prepared after obtaining the advice of the scheme actuary.
Yes.
So if they're if the claimants are impugning what the directors did, they must also be impugning what the scheme actuary did, because the scheme actuary
Yes.
was given the advice.
Yes. And that they're also suggesting that the directors should have known that the scheme actuary was wrong. And there's no explanation as to why they should do any of these. Could have done, let alone should have done any of these things.
Well, if it had been the case, that at some point in 2021, it was blindingly obvious that taking the valuation date at the 31st of March 2020 was a wrong thing to do,
Yes.
then it's inconceivable that the scheme actuary wouldn't have said so.
Well, yes. And so it's inconceivable that the trustee would have proceeded with 2020. Because if you take away bad faith, there's no reason for it to do that. Now, I'll deal with claim 2 very quickly, because it may be that it's now only said to be a consequence of claim 1, but because it's dealt with in the judgment, I'll say a couple of further things. If it's a standalone claim, the appellants would need to show two things. One, that there was a good enough case of unlawful discrimination. Two, there was a good enough case that the directors were in breach of duty. They failed on both counts in the judgment. On the first question, their case is based on an impermissible comparison because it says anyone, a young person earning benefits now, has 30 years in the future, say. And those benefits, because of these changes, will be less valuable than an older person who has 30 years benefits in the past. And that is not comparing like with like. It's dealt with in the skeleton, so I'm not going to deal with it in any detail. Section 23 of the Equality Act requires comparisons made for these purposes to be in circumstances where there are no material differences. It's hard, in a pensions context, hard to imagine something more material than comparing pension earned in 1985 with pension earned in 2035. That's the comparison made. It is a hopeless comparison. And there's no authority that the claimants have been able to identify that permits a comparison between what someone earned in the past with what someone else is going to earn in the future when both of them are earning exactly the same today. So it doesn't get off the ground. In any event, the directors were told this wasn't unlawful and were told in the circumstances they had no option but to agree to the JNC recommendation.
Sorry, where's the evidence? I mean, what's the references to back up the last point you've made?
This is dealt with in the judgment. This is in the core bundle. I think it's tab 16, page 240. And that's at paragraph 171 and 172.
Yeah.
The claim 3 in relation to costs, I'll deal with fairly shortly. It's the entire claim is based on some fancy footwork with the figures. It is striking that the claim compares 2007 with 2020 because at the time it was done, the figures for 2021 were available. This is a point made by Mr. Justice Leech. And those figures were slightly different. They showed total costs of 147 million, so there had been a drop from a high point of 2020. Rhetorically, we asked why the appellants had relied on 2020, other than because they were the highest figures, rather than most recent. There's no answer, so far as I'm aware, to that rhetorical question. But when one looks at that, or takes into account starting point of 38 million in 2007, end point of 147 million in 2021, as the learned judge analysed at paragraph 183 of the judgment, and as we're there, this is page 243, he simply doesn't accept these are super inflationary increases. The 2007 figure should be increased by CPI. wasn't even in use for some of the period, but it's a conservative increase, puts the 2007 figure at 56 million, and bearing in mind the increase in assets, the equivalent figure, prorated to take account of the asset growth, 2021 will be 152 million, which is almost exactly what it was. It was a little bit lower. So there was just no superinflationary increases. They were based, the suggestion that they were based on looking at some of the figures without any kind of rigour. What's also developed in the evidence, but I'm not sure we need to go to it, is one has to look at the context. In 2007, the regulatory regime was much lighter. Since 2007, USS opened a defined contributions section. So there was a new regulatory regime. They became a master trust. So there was a third regulatory regime. And when they brought the investments in-house, the in-house subsidiary, USIM, was an FCA-regulated investment management company. So there are 4 regulatory regimes that need to be complied with rather than just one. It's inevitable the costs have gone up.
It costs more money to do that.
Yes, my lord. And there is, of course, an irony in the fact that the appellants complain that USS has to spend money when it's had to spend money resisting this claim that's been brought, we say, with very little attention to detail. Claim 4 is the climate change claim. And the case is set out, we say, in quite vague and aspirational terms. Pleaded case requires an immediate plan for divestment to be introduced as soon as possible. I must say, until yesterday, we thought that was a suggestion for there to be immediate divestment, but that may not be as clear as it was. But there may be genuinely held differences of view on the question of divestment as the proper way to deal with climate change itself and engagement. There's no consensus. The USS, the scheme, has taken something of a middle path because it has divested in circumstances where it considers engagement is of no use, and that's, for example, with the thermal coal. And what the claim's really seeking to do is the claimants want to impose their view, which is that divestment is the only way forward, onto the scheme by imposing specific obligations upon the directors to go down the path of, or to require the scheme to go down the path of divestment. Now they realise that they can't bring this claim on the basis that they say it's better for the planet because there's no consensus that it is. And what's more, the authorities, Cowan and Scargill and Palestine Solidarity Campaign, don't allow them to say ethically, or the ethical outcome should be the driver. The Palestine Solidarity Campaign, and indeed Cowan and Scargill, you can take matters into account where the majority of the members may share that view and it will cause no financial risk. But that's as far as it goes. So this isn't brought on an ethical basis or on the basis it's better for the planet.
Well, it begs the question, doesn't it, to what extent are the views that these claimants no doubt hold representative of the views of the membership of the scheme
Yes.
generally.
Well,
We were shown that survey,
the survey,
65% of 0.5% or whatever it was.
65% of half, but yeah, it's about 1,200 members, give or take, which is insignificant. Reference yesterday was made to the crowdfunding. 11,000 people have contributed, even if one assumes that they all contributed because of Claim 4, rather than defending their benefits, which is a stretch. But even if we do that, that's 5% of the active members. So it's that wouldn't get off the ground. But the claimants appreciate that because they brought the claim on a financial basis, but they are still seeking to wrest control of the power to decide what's in the financial interests of the scheme from the trustee and its directors.
Well, I mean, this is the type of claim where, I mean, I'm not sure that there is any identified loss that has currently been alleged to have been suffered. I mean, linked to the question of what's the alleged breach. I mean, at one point, I think it's said in the pleadings, and Mr. Grant suggested, there's been a breach up to now. And then on another occasion, it was failing to have a plan to divest immediately or as soon as practicable, so looking to the future. Just focusing for a second on that latter question.
Yes.
As I would understand it, if beneficiaries think their trustees were adopting an inappropriate investment strategy qua trustee, then they have a right, do they not, to contend that it's a breach of trust?
Yes, and there could be.
I mean, if I mean, you know, they are beneficiaries, and if the trustee is breaching its trust in some way, they can.
Yes.
This is a situation where they can see. It's not a question of the trustee not having the funds to meet a damages claim in that respect, because we're looking forward. They're looking prospectively forward. So, as I would see it, a claim against the trustee saying you are not adopting an appropriate policy for the future is one that can and should be made directly by beneficiaries against the trustee.
Yes, and that was the approach taken by Mr. Justice Leech.
Yeah. So, I mean, in a sense, that what you're saying is that this is an attempt to wrest control of that investment decision from the trustee. To what extent, in such a case where beneficiaries are pursuing a trustee, they either have to do it on their own bat, off their own bat, presumably, or else they've got to do it on a representative basis, being properly appointed to represent the interests of a number of people holding
Yes.
the same view.
Yes,
I mean,
and they should do that as either as a direct breach of trust claim or as an administration claim. They should say no reasonable trustee would invest in the way that the trustee is investing.
and if the court says we agree, no reasonable trustee would invest in the way the trust is investing, then the directors of the trust would be bound to procure that the trustee gives effect to that.
Yes.
You don't need to go through to the directors
No.
to have that issue resolved
No,
appropriately.
and that's why the corporate derivative claim vehicle is just an unnecessary complication, quite apart from the fact that the various boxes are ticked.
But it's also an attempt to avoid the inevitable, if this were properly constituted as some form of trust claim, the inevitable requirement that they would have to demonstrate that they were somehow representative of a sufficiently large body of members of the
Yes.
scheme that the court would permit this to
Yeah.
continue.
Or that if they did want to pursue it as an individual pensioner, or sorry, individual member of the scheme,
Yes.
individual member of the scheme, which I think you can do as a single beneficiary. But what you wouldn't do in that circumstance, absent good reason, is to get an indemnity from the funds.
No, and I don't think there's any secret that it would be possible to bring the claim, to make an application for prospective costs, face the test under Re Buckton. I think maybe the claimants didn't fancy their chances there, so they sought this complex vehicle in order to avoid problems caused by multiple interests and to avoid or to improve their position on costs. We say they're both reasons to refuse permission rather than grant it, and I'll deal with that very quickly on discretion. But here, if the, just dealing with the corporate route, because that's the one that's taken, the well-established principle is that it's for the directors to decide in good faith how to promote the success of the company. That's the Client Earth case, or makes that reference in similar circumstances. I won't go to it given the time, but that's at tab 88, page 1882.
I mean, that's fine as far as companies go, where there's
Yes.
no pension overlay. You know, I don't doubt that as a proposition where you're just dealing with a shareholder saying my company should adopt a different business approach.
Yes.
Of course, it's for the directors to decide the business approach of the company, subject to the usual parameters and controls. The issue here is there's a pensions overlay.
Yes.
These claimants are not shareholders.
But
They are people who are beneficiaries under a pension scheme.
yes.
And that's why I suspect going off into that point about a commercial company doesn't actually help the real issue in respect.
Well, my Lord, it certainly doesn't take matters very much further. I think I do need to make some factual points on behalf of the company, which is say the underlying claim here is really misses the point because it takes no account of quite how much has been done by this pension scheme in this context. And I'll just refer to one document, I think, for now, and that's in Supplementary Bundle 2, tab 51.
So 51.
Yes, this is
Second one is B.
the tab 51 at page 569, because it brings some of the relevant materials together. And it's headed USS announces net zero ambition. In my submission, if it had been headed our plan, the claimant's case would disappear entirely, but it identifies steps that have been taken and are going to be taken. The third paragraph notes the long-standing history USS has in recognising climate change as an investment risk. The gist of the claim is you haven't taken into account the risk. The fact is USS was at the forefront of identifying this risk more than 20 years ago. And in terms of practical steps taken recently, you'll see at the end of that paragraph, there's reference to the announcement of plans to exclude and disinvest from various sectors, including coal mining. Then at the bottom, on the next page, the investment company is in the process of establishing short, medium, long-term targets and programs to deliver on the ambition. Likely actions will include various things, including considering divestment. So this is what I say when there's been a middle road. It's not ruled out divestment, it's just not adopted it as a wholesale strategy. one of the things I would point out, and the evidence in support of the claim said in effect, you should be investing in renewables rather than in fossil fuel companies. There's already, at this stage, £1 billion invested and committed to projects in renewable energy. That figure in the training materials, I won't go to them, but it's tab 67, page 718, identified that the figure had increased to 1.7 billion then. And also what was called the climate tilt to £5 billion of investment announced early last year before this hearing was heard, shows that by which the investment in funds that take into account climate and carbon emissions, both in terms of the sectors they invest in and the particular investments within particular sectors. So they are taking action. And the claimants say we should do more, but that simply doesn't identify any actionable case of any sort, whether it's brought as a derivative claim, beneficiary derivative claim, direct claim. It would, of course, be disastrous for a trustee to say we have holdings in Shell, they've done well, we have decided we are going to keep them for another 50 years, come what may. But that's not what's happened. It would also be financially disastrous if they said we are going to sell them on the 15th of June 2028. So it's just not clear what they're supposed to have done, what the trustee or the directors are meant to have done and haven't done. And that's no proper basis for a breach of director's duty claim. I'll deal very quickly with discretion. Obviously, a judicial decision in relation to discretion is difficult to overturn. Here, on claims 1 and 3, I'm seeking to overturn the decision on discretion. Claims 2 and 4, Mr. Grant's trying to do that. I say that there are very fundamental differences, and it's paragraph 153 of the judgment, that's tab 16 in the core bundle, page 233, which in some ways finishes the case where certainly finishes the submissions where my submissions began, because it deals with the questions about forum and why this approach was taken. And it very shortly, at 153, Mr. Justice Leech records Mr. Grant's submissions. Beneficiary claims are rare. Practicalities involved in trying to ensure 4,700 members properly represented meant that Mr. Justice Leech, could not be confident it would be straightforward or that the claimants would be able to make or fund a claim. We submitted that the need to give other members of the scheme the opportunity to be represented, which was being denied to them, was a reason to refuse permission not to grant it. In some cases, interest-based representation. If this was just an administration action where they were saying, well, no trustee would adopt CPI 0.29, that would be relatively straightforward. Subject to costs, they could seek an order from the court appointing them to represent everyone in whose interests it was to say no reasonable body of trustees would adopt that figure. Someone else, the trustee or another representative beneficiary, could be appointed to argue the opposite. So it's possible to do it in that way. That claim wouldn't work though, because they've now accepted that they don't say no reasonable body of trustees would have made either of these decisions. But ultimately, this route, the route of a common law company derivative claim, has been chosen to avoid those problems, even if it's a matter of discretion rather than a matter of an absolute bar. They are the most powerful reasons to refuse permission. And it is one of the rare circumstances where an appeal court can and should interfere with an exercise of discretion by a judge. On 2 and 4, climate change case, discrimination claim, claims can be brought by individuals if they want. There's no good reason to interfere with the exercise of discretion in those cases. My lords, my lady, if I can have one moment.
Sure.
Unless I can assist further, those are my submissions, or our submissions.
No, thank you very much indeed, Mr. Chairman. Thank you. Yes, Mr. Green.
My lord, would it be appropriate to have a few minutes adjournment?
Well, I think we should just crack on, Mr. Grant, frankly.
But then can I have a minute to take
All right, we'll
points
take a
from
5-minute
behind?
break. We've still got to finish at 12:30.
I understand, yes.
Right.
Oh, I think it's because we've been kind of, on autopilot, just going in by the judges. Yeah, I did. Just say yeah. Halfway there.
So I did. I took one of the company
No, you were fine. We came up fairly. Fine, yeah. Sorry. Oh, well, yeah, because this friend of ours had said it'd been to this pub. Leaving without backup. Yeah, no. Only 2 other teams. That's that much. Yeah. Lucky you want Hugo's one. Yeah, exactly. There's just no. Oh, because we were all like just writing different combinations.
All right.
Yeah.
My Lord, by way of structure, there are really two parts to my submissions and reply. The first part is to deal with what I say is logically speaking, the first question this court has to decide, which is whether Robertson Gill is applicable and is engaged here. There's an awful lot in that. Thereafter, I have a number of points to make in reply to what my learned friend has said and his submissions yesterday and today, dealing with the various bits of the claim, including some evidential and forensic points. And say logically and conceptually it makes sense to start with the Robertson Gill point first. The question is, first of all, whether that beneficiary derivative claim or procedure is applicable here, and if so, what consequence does that have for the possibility of any common law corporate derivative claim? And also, what impact does that have on the characterisation of the claim being won by or on behalf of the company against the directors in alleged breach of their duties? In my submission, it's obviously a matter for the court. The court does need to express an opinion on that point, having raised it in the way it did. Because if the court is correct and Robertson Gill mechanism applies, that would be a very good reason why there would be no need to fashion or extend the Fort Gill kicker principle to fill the factual circumstances here. Conversely, if I am right and Robertson Gill doesn't apply, then it at least raises the question as to whether the Fort Gill kicker concept of sufficient interests can apply to the circumstances before the court. So of course not a complete answer to the question, and it may well be that the answer is, well, it is not limited, but it doesn't apply here. But that's a secondary question. As to the first point, the claimants say it's not possible for the Robertson Gill procedure to be engaged, ultimately because the company trustee's cause of action against its directors was not held on trust. The proceeds of the claim were not held on trust. Starting point, fundamental but important, directors only owe duties to their company, to the company.
Just pausing there. Issues, well, picking up the environmental point right at the end. I don't know whether you're going to distinguish between the causes of action, but if your cause of action for in relation to environmental policy is purely forward-looking, then I'm not at the moment sure why the question of where the proceeds are held is relevant. It's simply a question of prospectively, what should the trustee be doing in relation to investment policy?
That leads to a bigger question, which I'd like to deal in due course, which is what is the question of the relevance of loss in all of this, given the relief being sought?
Just so we don't overlook it. I'm
No.
not sure the same against
Again, that's important, but it feeds into various things such as the fact that this is a not-for-profit company, the nature of the claims, how can they said to be held on behalf of the beneficiary? There's a multifactorial element to this. So I say, first of all, directors only owe duties to the company. Secondly, if the company brought the claim, would the proceeds be on trust in the way that would be so apparently if a beneficiary brought the claim under the Robertson Gill procedure? Next point, could a company member bring a statutory derivative claim under section 261? I submit it could.
Sorry, could a
Company member bring a statutory derivative claim? Take the example I initially started with Professor Hutton, not applicable now, but any member of the company, could they bring a statutory derivative claim? And I say the answer is clearly yes. That raises the question, would the Robertson Gill procedure only be engaged if a member declined to, and how would you verify that position? But it also begs the question, if the member brought claim for breach of director's duties, again, would that claim effectively be held on behalf of the beneficiaries?
So you're postulating in the current case a dissenting board member or a board member not involved in the conduct of, complained of, saying the rest of the board, let's say, have had
Yes.
their hands in the till, or are doing something which would be a breach of duty to the company. I want nothing to do with it, and what's more, I think the company should be suing them. But they obviously will vote me down at a board meeting, therefore I ought to be entitled as a member to use the corporate
Exactly so.
derivative structure.
Yes.
So that's a possibility. If that director member had a sufficient interest to do it, which might be said to be, this would be a rare case in which it would be an interest other than financial, because of the rather curious arrangement where all the directors are the members. So that might be a possibility.
Well, my lord, may I say that in fact, if it's a statutory claim, they're a member. They can bring that claim.
Well, they can go through the statutory
They go
process
through, yes, sorry, you're
and
quite
see
right.
whether they can satisfy
Yes.
all the tests.
Yes,
Fine, okay, I understand that is available as a possibility,
Yeah.
were that the case. But that's not what we're dealing with.
no, but I'm just trying to understand, I'm trying to set out the structure of the different options, and it's useful in my submission to understand the architecture of the possible claims.
Okay, all right.
Now, the next question is, does Robertson Gill apply to claims by companies against directors? And in my submission, it doesn't. It certainly doesn't expressly. That wasn't the point in Robertson Gill. That was a claim against professional advisors. Historically, the claims by trustees were against debtors. Now, they're frequently against advisors. The two cases we've mentioned, the Bradstock case and Robertson Gill itself, are examples in rather different contexts. The historical rationale is that beneficiaries could compel trustees to sue the trust, where the trustee failed to protect the trust estate. One sees reference to that.
Sorry, can you say this? I think you misspoke. Can you say the sentence
Yes, I may
again?
have done. The historical rationale for this procedure, or predecessor to this procedure, is that the beneficiary could compel the trustee to sue in instances where the trustee has failed to protect the trust estate. Hopefully that clarifies
Yes,
the
it's
initial
not what you said the
mistake.
first time, and I think
No, well, I apologise. I say inherent in all of this is that the benefit of such claims are held on trust for the beneficiaries. I say that's a necessary part of this procedure. The next point is whether such procedure would circumvent the position on dogleg claims taken in the authorities.
well, now you've got to be careful when you introduce this expression dogleg.
Yes.
I understand on the authorities that the expression dogleg has
Yes.
just been used to describe a Robertson Gill type
Well,
claim.
If anything, there is very little between them. It's certainly not an attempt to bring a direct
Can you
claim.
define what you mean by a dogleg claim so that I understand it in your
Yes.
submissions? Because
That is
I
a-
personally would prefer not to use that expression.
No, right. But I think ultimately we get very close, if not to, the Robertson Gill mechanism. It's not a claim saying that in the circumstances the directors owe a direct duty to the beneficiaries. That's not the way HR and JAP in cases in Australia and
No, that's
Brexit have been
direct.
argued.
That's a claim which has
Yes.
been repeatedly rejected,
Rejected.
namely that corporate directors of a corporate trustee
Yes.
do not owe
Yeah.
fiduciary duties to the beneficiaries of the trust.
Absent
Direct.
things like dishonest assistance or whatever.
Yeah, that's not dogleg, that's just straight.
That's direct.
That's been out,
Yes.
said, no.
The dogleg, to use that slightly unfortunate language, is an attempt to sidestep that position, the fact that direct claims have been rejected, to say that yes, we acknowledge that the claim is really the claim of the company against the directors, but nonetheless, that claim or the proceeds of the claim would be held for our benefit. So we are entitled to bring the claim.
So
And it's
it's a beneficiary saying that the corporate trustee
Yeah.
should sue its directors and hold the proceeds on trust for the fund.
Yes. And the motivation, frequently, at least perhaps invariably, is where the corporate trustee doesn't have assets to meet the breach of trust claim.
Well, yes, or yes, I could be. You know, it's well, that may be the motivation, but in law, you're still saying that for some reason there's a breach of trust.
Yes, I'm not saying that that has any impact on the legal analysis, and simply the circumstances in which these claims often, not invariably, come about.
Yes, it's right. Okay.
Yes.
And often they come about either because you are the third party, is an advisor, or alternatively you're saying that the directors have breached some fiduciary duty, they're dishonest assistance in some scheme or whatever, and therefore any proceeds received from them, it's then suggested would be trust property.
And I think
Then you're distinguishing that situation from what you would say is a pure vanilla breach of section 171 and 172 in relation to duties owed solely to the company.
now, in terms of the support for the ability of beneficiaries to bring dogleg claim, to use that phrase, Gregson's, the deputy judge, held that the claim could not be sustained. That was not a single trust company, Gregson. Potential point of difference in HR and JAPS, Justice Lindsay did not strike out the claim. That was a single trust company case.
And the material distinction is a view as to the likelihood of the proceeds being held on trust for the fund.
That's certainly one way of looking at it. Lewin, in chapter 43066, one of the extracts I handed up yesterday.
43066.
Yes.
067.
I've refiled it. Yeah, sorry, 067, quite right, my lord.
Yeah.
That passage there gives the potential difference, making the point that the objection is that the claims by the company against the directors form part of the corporate assets of the company. And that was the point which my Lord Justice Snowden considered to be extraordinary as part of my submissions over the last 2 days, that that claim would be held as part of the corporate assets of the company. The learned editors of Lewin say that objection is particularly strong in the case of a commercial trust company. They provide, on the basis of HR and JAPT, a potential caveat in the case of a one trust, no asset company, created and administered solely for the purpose of administering the trust in question.
Yeah, well, I mean, sorry, but that is, sorry, with respect, my surprise was that on the fact of this case, where you have a sole purpose, one trust company, I mean, if your clients' claims where they are financially, put aside the future environmental policy claim for a second, and put aside the discrimination said to have taken place against cohorts that they don't belong to. But let's take the claims where they are directly financially interested. If they were right that the fund, or that they have suffered because the fund has suffered, and I'm narrowing it down now because if their only beef, as it were, that there's no overall problem as far as the fund's concerned, it's just that they've been disadvantaged and others have been advantaged in the division of benefits. If they say overall the fund has suffered, then I would be surprised, well, I was surprised that your primary submission was that the recoveries would not be used to replenish the fund.
Yes. And I have two answers to that. One, the basis for my submissions is the law and the material I'm taking the court through now.
Right.
And secondly, the point that it's academic in this case, given the nature of the relief sought. Because the relief is declaratory.
But declaratory, it identifies loss.
Yes.
And it identifies loss to the company.
Yeah.
And so you are, unless you're right on that point, the relief that you seek doesn't go anywhere. I mean, it's just not merited.
Right, no, because it's still a declaration as to the lawfulness of what has happened, including declaration of potential to loss. But that declaration, that wouldn't be part of the credit, that wouldn't go to the creditors in any meaningful way, in the way that an award of damages would. And we'll see when we get to the article in Underhill, the comparison drawn with some of the old personal injury cases, and the fact that money then did go to creditors unintentionally was the driver for the 1930 Act, in part.
And presumably, our company here does have creditors.
Of course it will do, yes. Those who, yes.
I struggle with your point about academic. Each of the declarations you seek in relation to each head of claim includes a declaration that the breaches have caused or will cause the first defendant loss. It's part of the declarations you seek. So the question of where the loss is, sorry, maybe I've misunderstood your comment about it, it's all academic. You seek in each case a declaration that the company as an entity,
Yes.
I think, it's the only way I can read it,
Yes.
has suffered loss.
Yes, but, for example, take the environmental claim. There are backwards aspects and forwards aspects of it. They're not mutually exclusive. But in terms of the forward aspects, we say there is a loss suffered that may, even assume it's crystallised, may be difficult at the moment, will be subject to inquiry as to precisely the amount of the loss.
But sorry, the company does not invest in anything at all, least of all, companies that involve in climate change. The company is not an investment company. The company acts as a trustee.
Yeah.
It doesn't hold investments.
But then, if
In its own right, sorry.
I understand, yes, but if the logic of that argument is correct, then it still means that what is happening here is that a claim that is, on the face of it, is a company's claim against the directors, for whatever relief that is sought, is nonetheless held on trust, or the proceeds of it are held on trust for beneficiaries.
And therefore, it doesn't matter, does it, whether we're talking about money or whether we're talking about other relief. What we're talking about is the shows in action held on trust, and therefore it is the result of the shows in action, whatever that result is, held on trust.
Yes.
So there's no real distinction.
Sorry. Yeah. Sorry, I'm just not playing catch up here. Your environmental claim.
Yes.
The company holds no investments in its own right. So the only investments that the company holds is a legal title but on trust for beneficiaries under the terms of the scheme. How can the company, in its own right, suffer in any way as a result of the investment policy which the scheme is subject to?
As I say, that the loss of a not-for-profit company has to be looked appropriately and has to be looked in the context of the purposes, and that is where I invite the court to read. We touched on a bit of this morning. Article 71, Article 74 of the articles, Section 172(2), showing that how one views the benefits of the success of the company through the prism of the purposes for those on whose behalf the company operates, namely the scheme and the people who are members of that scheme.
But you still maintain that the damages would be held not for those people.
And I'm in the middle of exploring that. So on the basis that the claim by the company, primarily, against the directors, the benefits of that would be for them. On the basis as recognised in Gregson and supported by Lewin, at least, that in the case of a commercial trust company, the assets, the claims where the company against the directors form part of the corporate assets of the company. The question is why there would be a difference in the case of a single trust company. And why is it? Is it that the purpose of the company is such? Is that the magic ingredient that causes the claim to be held on trust? Even Underhill and Hayton, passages your Lord helpfully via my lady directed the parties to yesterday, even that notes the fact that the authorities all say that dogleg claims don't work, but is critical of how the claims have been characterised, and says that in each case the claimant's case has been put too high. That's Article 71.9. Your Lord looks troubled.
Well, only just, I don't recall Underhill saying it in those terms.
This paragraph again.
71.9 of Underhill.
I'm afraid I think I've lost Underhill.
So you say that it's the last sentence, the dogleg claim has been considered to be wrong as a matter of law in Australia, Jersey, England, and at least doubted in Guernsey.
Yes.
But it's not really dealing with the point made by Lewin, where Lewin is saying actually it's not really it's not simple as that.
No.
It's where you have a multiple trust corporate trustee. It might not be possible to connect the recoveries to the particular fund, but where you have a single trust corporate trustee, you do.
Yeah. Well,
And the dogleg claim, i.e. the beneficiary derivative claim, that's what I call the dogleg claim. It's a beneficiary derivative claim.
But
of the Robertson Gill type, says Lewin. Well, it says it's not unarguable.
I was about to say that, my Lord. That's as high as Lewin puts it, on the basis.
That's the only authority there is directly on the point.
Exactly. And I say that that's weak foundations for arguing or contending.
Why on earth, if you have a single? I mean, you see, the trouble is, I think your attempt to say that you have to, when construing the duties of the directors, understand that the purpose of the company to whom they owe their duties is to act as trustee for these beneficiaries, and that's their purpose. Why isn't that tantamount to saying that, in effect, recoveries would be held solely for the fund? I mean,
Because the company has no other purpose than to act as a trustee
as the
for
trustee
the
of this
benefit of
fund.
the beneficiaries.
For what other purpose, in a sense, is the litigation being pursued, and why isn't that good enough to, by necessary implication, reach the conclusion that the proceeds must be held on trust for the fund, like everything else that the company does? I mean, you come so you try and make a distinction of it, but the more you say it, the more I'm thinking.
No, well,
it establishes the
well,
proposition.
it's an extremely difficult point, and it was at a point. It was observed by, I think, my lady yesterday that I was concertining the company and the trust. But in my submission, the same is true as if a Robertson Gill mechanism is applicable, because the consequence of that, if it were true, would be that the beneficiary would then be able to bring this claim, which would be held on the benefit of the trust, notwithstanding that the claim it's seeking to enforce is a claim which, on the face of it, is beneficially held by the company against the directors. So whichever mechanism one works, I say that that question of concertining is brought into relief.
Well, yeah, it is. Yeah, okay, well, we'll have to think about
Okay.
that. Well, anyway, you
No.
say a beneficiary derivative claim of the Robertson Gill type is not available in this case.
Yes.
And if you're wrong on that, then actually there's that. I think you said earlier that would be a very good reason why this corporate, this common law derivative claim of the corporate type shouldn't be allowed to proceed.
Yeah. And if we're wrong on it, the claim procedurally has gone on into misconception, and I'll explain what did happen. If I'm right, then the point doesn't arise, then one has to look at the application of a common law corporate derivative claim to the facts of these cases. But that's why I said 15 minutes ago, this question is now so fundamental.
That's why we raised it at the start of day one.
I appreciate it was done, and I didn't immediately appreciate it, but it is a very important decision, very important point. And it's, sorry, my lady.
We're going to have to decide where we go on that point. But is there any other authority you want to refer us to?
No, that's the extent of it. I mean, it's simply to say that the best researchers we have done in the time have not been able to identify any claim against directors by a company or on behalf of a company in which the Robertson-Gill procedure has been availed. And that was the point I was seeking to make to my lady 2 days ago, to say that the difference was the fact that in the paradigm examples in the Robertson-Gill procedure, whether it's a claim against debtors, whether it's a claim against advisors, those claims are held on trust. Compare and contrast, we say the claims brought by a company or on behalf of a company for breach of duties by the directors, we say those are not.
And the distinction that I made earlier, which might hold or might not, between as a company alleging breaches of 171 and 172 duties owed to you, as against saying, aha, my directors actually have been involved in dishonest assistance or whatever, and therefore there is a separate fiduciary duty which might then be an action which would be held, or shows an action which would be held on behalf of the trust, which might be a different animal.
My lords, my lady, this debate could continue for a long time, except it can't. I would like to just make a couple of points as to why or procedurally what has happened, and then turn to the substance of my points in relation to the underlying claims. Now, it's clear, my learned friends showed you yesterday, that my client's position was to disavow the possibility of a Robertson-Gill claim. And that formed part of the submissions I made 28th of February last year. Not until yesterday afternoon has the company ever said that Robertson-Gill would apply to this situation. Yes, they don't choose the turf, but they never took issue with it. And we got the first, albeit slightly reluctant, acceptance of that from my learned friend the second time of asking yesterday afternoon, where he said, yes, Robertson-Gill would apply. Now, the company's stance was that an application for permission was the appropriate procedural step, which self-evidently it wouldn't be in a Robertson-Gill style application. And I invite you to look after the hearing at paragraph 13 of my submissions for the hearing on the 28th of February last year. They are tab 7 of the supplemental bundle we handed up on Tuesday. And one can see further from the judgment, paragraph 33 even, the judgment. So core bundle, tab 16, bundle page 180. I'm sorry, that's the wrong reference. It's paragraph 28 on page 178. I apologise. You see there, the company accepted the possibility the pension scheme members could bring a multiple derivative claim, and the judge held that my learned friend was right to make that submission, to adopt that position. An example given there. Now that can't be read in any other context than what it is there. An express recognition as to the possibility of applying the common law corporate derivative claim to situations other than those which had previously been before the courts. Moving on, I say that this is properly a common law derivative claim, and it is a proper application or extension of test, perhaps most helpfully set down in Fort Gill-Kicker. The whole premise of this claim is that the director members are wrongdoers, so the company is disabled from bringing the action. The company is a section 172(2) company whose success is to be judged by reference to its purposes. person who will benefit from the proper performance of the purposes will be an appropriate person to bring the claim on the company's behalf.
Sorry, could you say that last part?
Certainly. A person whose success is to be judged by reference to, a person who will benefit from the proper performance of the purposes will be an appropriate person to bring the claim on the company's behalf. And with respect, that answers my Lord Justice Snowden's question, or point that his Lordship has as much connection to the company as my clients do. The answer is respect, your Lordship doesn't, because the company doesn't exist for the purposes which encapsulate your Lordship.
But the reason, my follow-up point was, the reason your clients are not in the same position that I would be in as a sort of mere outsider and busybody is precisely because they are beneficiaries
Exactly.
of the trust.
They're the
That's
people.
why
Yes.
it has to be focused on their interests in that capacity.
I say that the charity case, the Abdul Mahmoud and Egyptian Association case my friend referred to yesterday, is quite instructive from our perspective, because in the case of a charity, as the court will know, the Charity Commission, Attorney General, can bring a claim if directors breach their duties. The pensions regulator has no comparable powers of action. So there's no prospect of the pensions regulator bringing a claim here. There's lots of other powers, but not the same powers which were held to be potentially critical in the opinion of Lord Justice Newey in that charity constituted as a company's circumstance.
In defining whether your clients have a, quote, sufficient interest, well, I don't know whether that's the appropriate wording, but whether they have an interest which justifies the bringing of this claim, do we look just at their particular interest, or do we say, well, but are they also representative of a wider cohort of individuals?
In the first question,
And so how?
the first question, one of standing, it's just the first. So you don't look to see whether they are representative. Perfectly relevant consideration on the discretionary stage, but not for the question of standing. Simple point is, my client, as has happened, of course, it could have been Dr. Smith and Miss Jones who brought the claim, but it's not. They are people with the closest connection to the company because of the lack of tiers, the lack of verticality, everything else. Another point I want to deal very briefly with is, and I do this with some trepidation given that we're going to pure company law with my lord, is the question as to whether all shareholders have the same interest.
Well, obviously, if there are different classes, the answer is no. There are different classes of shareholders, but
yes,
within a class, I mean, a lot of the companies are, where there's just a single class of ordinary shareholders.
But there will be companies with much more complex structure, preferred, and all sorts.
Yeah, I mean, it's an interesting question whether,
Yes.
for example, a non-participating member could bring, and it may be, your point is that if there's a gateway question, it's just simply are they a member?
Yes.
And then it comes down to a question of discretion.
Yes. Exactly. And the reality is that all the cases we've looked at in the core bundle are disputes between shareholders. I say but the vast majority of them is where two shareholders, one will have control of the company, one won't, and it's a minority shareholder who by definition in a way does not speak on behalf of the entirety of the class, is nonetheless has the ability to bring the claim on behalf of the company.
Yes, because it's usually the majority shareholder who've managed to get themselves onto the board by holding the majority of shares and voting themselves on, and then steal the assets of the company, let's say, and then refuse to allow the company to sue them. So, I mean, that's the paradigm.
That's the paradigm, but the important point to draw from that paradigm, or the extreme example, is that one doesn't have to look at the totality of the interests of the shareholders, because the vast majority of the majority...
No, well, wait a minute. Wait a minute. You don't at the gateway test, which I understand you saying, but when you come to look at discretion, you most assuredly do, because you are directed by statute to approach the question by reference to what would a independent director acting in accordance with his duties to the company do, i.e. would he consider it's appropriate for the company to bring these proceedings? I mean, that's section 26.
We'll check.
Whatever it is.
Yes. But the
Yeah, so in a sense, the interests of the members as a whole come in at that stage.
they do come in at that stage, but say not at the standing stage.
Not the gateway standing.
Yeah.
I understand your solution.
So,
Okay.
moving on, the 15 minutes I remain, if I can turn to the substance of the matters. And may I just say at this point, and the court may wish to reflect, if on the points I've just addressed the court on, the court considers it would be assisted by written submissions, I for one would be happy to give them. Turning then to the substance of the claim, as I said a few moments ago, first thing I asked the court to look at is to put the Articles of Association, particularly Article 71, next to Section 172 of the Companies Act, to understand the purpose for which this company exists. Not-for-profit company, the purpose revolves around them providing university benefits. That is also relevant to the question of the test of the duty to act within powers. Section 171B, the director must only exercise powers for the purposes for which they are conferred. That is an entirely objective question.
It's not entirely objective, because I think I misspoke a little earlier. If you look at it, Claire's, what Lord Sumption says is, in a sense, you first of all have to define what the purposes are for which the power is conferred, and that is an objective question. It's a matter of law. You know, what is that power there for? But you then have to ask the subjective question, which was in the excerpt that you took us to on Tuesday, which is, what was subjectively the purpose that the directors had in exercising the power? And if the two don't match, and there's arguments about whether it has to be dominant purpose, predominant purpose, or whatever, but if the two don't match, then you've got an abuse of power. That's the framework.
Well, as Lord Sumption says, paragraph 21 of the Clares, the statutory duty of the directors is to exercise their powers only for the purposes for which they are conferred. That duty is broken if they allow themselves to be influenced by any improper purpose. And that's not a conscious, and there's no element of mens rea in there, no element of bad faith. It's simply, are the purposes by which the directors exercise their powers improper or not?
Well, I'm sorry, which tab is it, Claire's in? Remind me, 63?
In Clares is 63, well remembered, my lord, yes.
63, but what Lord Sumption said at page 867 of the authorities bundle, between D and D, that the test, he says the test is necessarily subjective. I mean, I think you've got to read it in the context. I think you do have to identify what was the purpose for which the directors exercised. And that's necessarily a subjective question, because it's looking into the mind of the person.
And then see, does that come within the scope?
Yes. I mean, there's an objective first question, what's the proper purpose as a matter of law? And then the second is, why did you do it?
And then a third conclusion, yes.
Correct, yeah. Okay. So you do need to show that subjectively these directors' purpose in doing the matters which you complained was not that which objectively they should have been pursuing. And that's the framework, isn't it?
Yeah. In my remaining 11 minutes, can I now turn to the substance of the matters as quickly as I can? I said more to be said, but nonetheless. Start supplemental, I think we can put the authorities confidently away. Supplemental bundle 2, it'll be volume B, because I'm going to the actuarial valuation.
Sorry, tab.
hadn't yet given it to you, my lord. 56, recollection, yes.
56.
Tab 56. Page 604. Now, perhaps the most stark figure on that page is the one which my learned friend didn't take you, and that's the comparison of the deficit at 31st of March 2020 and the deficit at 31st March 2021. In the technical provisions deficit, reduction from 14.1 billion to 5.6 billion. He drew your attention to the fact that the future service rate contributions, in fact, had gone up between those dates, as support of the fact as to why 31st of March 2021 would be no different. But that's only half the story, because all the figures given there, the contribution rates, are the future service contribution rates. The other aspect of this, the deficit repair contribution rates, to deal with all the accrued service, are not in there. And what we know from that is the massive reduction in the deficit, 14.1 billion to 5.6 billion. That was the experience since the valuation date. So that supports the impropriety of adopting the previous valuation date and calls into question the assumptions given. Much had changed since then. But nonetheless, the actuarial assumptions adopted were extremely conservative. And one thing I would ask the court to do, we don't have time, it may not be a good use of time, is paragraph 75 of the judge's judgment below. So core bundle, tab 16. It's page 200. Judge sets out the quotations I relied upon last year and made reference to 2 days ago. I would simply ask the court to read again those quotations and benchmark them against what my learned friend says is the duty of the trustee. And I invite you to draw the conclusion there is a significant and vital difference. The focus there is not just on paying benefits when they come due. It's the focus on benefits which have already been built up. Members have already been promised. That is a focus on accrued rights, which I say is inappropriate. If the court is happy, claim 2, I make just one point. So that's still within the judgment to page, paragraph 171.
Sorry, page.
In fact, no, sorry, it's not, it's a different point. The point I'm going to make is this. My learned friend said that the claimants made an impermissible comparison between the position of someone with 30 years service and someone with historic service. And if that were the way in which the claim was put, then I would respectfully agree with him that that is improper, because it's not comparing like with like. But that's not the way I put the point. The point is, let's take the reduction in the pension service accrual, reduction in the pension service accrual. For someone who has just started in the scheme 3 years ago, the reduction for their service earned from 1st of April onwards will have a particular disadvantage compared with someone who's been in the scheme for 35 years, again in relation to their service from 1st of April 2022. It is comparing like with like service. It is not comparing the position of service after one date on behalf of a young female with service before one date of an elder male. That's not the comparison. The fact that one of them will be an elder male and the other will be a younger female, that's simply the different cohorts, and that shows why there is an indirect discrimination, but it is not comparing unlike with something else. It's comparing like with like. In relation to the costs claim 3, in fact, if the court still has the judgment open, go to paragraph 183, which my learned friend relied upon as proof of the lack of rigour of the claimant's claim. Unfortunately, in 1831, the judge makes, so it's quite a fundamental arithmetical error, which was one impressed upon him by the company, and it's this. In 1831, effectively what the judge did at the company's submission is in just the 2007 figure of costs, but doesn't adjust the 2007 figure of assets. And so makes an unfair comparison because the inflated costs compared with the uninflated assets produces a greater ratio than would otherwise be the case. And one can test that very simply by going to the appendix to Mr. Gibbs' witness statement and looking at that gives the absolute figures and the percentages. The percentages, of course, will stay the same as long as one increases both parts of the equations. And that comparison shows quite how fundamental arithmetical error was made there. It's improper just to inflate the costs, but not the assets, because that distorts the ratio and would then suggest a much lesser growth or expansion in costs over time as a matter of real value. In the last, just under 4 minutes remaining, I wish to turn to claim 4. First of all, the survey. That's the survey commissioned by the company. To the extent that only half the responses were sent for further analysis, well, it's incumbent upon the company to do that analysis. If it thinks that that survey isn't representative or doesn't inform it sufficiently, then it's entirely within the company's gift to seek further evidence. But that is the evidence before the court. Nothing in the witness statement, nothing in the submissions to say those preferences, quite clear 2/3 preferences, are unrepresentative. No suggestion that that retired members, deferred members would have different views. So it's really not for the company to make issue of the limitations of that survey, which is the survey which they have conducted. My clients have no ability to do that. They don't have the data or the email addresses and the means of contacting what would be a large enterprise, hundreds of thousands of members. How could they? In terms of the other documents that have been relied upon, I'm going to take you to one document, tab 65 in a second. But first of all, yes, we haven't looked at it in the bundle, but at the beginning of the bundle, there is a very thought-provoking paper from 2001, I think it is, on climate risk. And credit where credit's due, that showed that the scheme at that time was probably ahead of the curve in considering such matters. The problem is next to nothing has happened in the next 20 years. My learned friend relies upon the document at 65, so he relies on a couple of documents. If one looks at the document at tab 65, 24th of January 2022, so after the claim had been issued, there's an announcement to introduce a climate tilt. Now, this change will affect over 5 billion of assets under management. Query how much of those 5 billion will be affected. It's a climate tilt, it's not clear, but even assume it's the 5 billion, which is far from clear. Nonetheless, the second paragraph is crucial. This will be a first important step in USS's path to achieving the ambition to be net zero. So first step and an ambition. Doesn't reveal a plan. That is the important thing. An ambition without a plan isn't really worth what it's written on. And that is absent here. And yes, the claim is focused on a financial analysis of risk. And the oddity is that what appears to have happened is the director's preferences as to, or the director's beliefs as to what they think divestment has as an impact on global emissions, which is driving their stance, rather than looking at the critical question, is the continued investment in fossil fuels for the interests of the company, and was that decision a proper exercise of the relevant power? Now, in my last 20 seconds, I just wish to conclude with one point, which is this. Claims 1 and Claim 4 may be very different contextually, but they are linked by this feature. Both are to do with the company or the general custodianship of the assets of the scheme. And we see a stark difference in the approach between the two of them. Claim 1, extreme prudence, reacting quickly to the events of 31st of March and deciding that evaluation needed to be done. Compare and contrast that with environmental claim, where notwithstanding the real risk to the financial returns of the scheme, we say nothing has been done. That difference, we say, is illustrative. Finally, on the question of discretion, which I haven't really addressed the court about, I would simply invite the court to read the relevant paragraphs of my skeleton in reply, where I deal with the point, including those which my learned friend has made today. And I'm afraid in the time left, that is all I can do.
So when you say, oh yeah,
Yes.
yeah.
Right.
And there's, my lord, I'm a minute over the guillotine you set,
Well,
which I apologise.
You've had, I think, enough time to develop your arguments and replies to Grant. If you haven't and you want to ask the court to put in further written submissions, you can ask us. But, you've referred time and again to effectively only having so much time left, from which I rather deduced that you were trying to suggest that we were pressing you more than we should do. That's not the intention at all. The hearing is fixed on a particular basis at the outset, and we've actually given you the best part of an hour and a half longer than you would normally have during the course of the hearing.
As I've said before,
If
but I
for whatever
repeat,
reason you think that you haven't had enough time, you want to develop arguments in writing, then by all means put in written submissions. We are obviously going to reserve our judgments, and we will let you have a draft in due course. That's for any typographical and similar corrections, not for you to invite us to reconsider our decision on the substance of the points. If you could also please pay particular attention to the terms of the embargo on the judgment, and the fact that it should only go to people who are involved in the relevant part of the decision-making process. As you know, there have been a few recent occasions when the embargo has been broken. It only remains to thank you all for the quality of the submissions in the case, which we found of tremendous assistance. It's not easy. We have to go away and think about what the answers are. Thank you very much.
All rise.